to this specific exception, which is included not in the patent text, but in the AI Act. So it is a new issue. Obviously, as we are lawyers, you have those who say yes and those who say no. They both have a good reasoning, and that's the reason why we have courts in order to decide between the two. At least when you have two good reasonings, it's better than when you have only one. But to decide, I don't have, and I don't pretend to have the answer.
They are oftentimes starting off with a data maximalist perspective. People grab whatever they can. So there are websites like there's a really good one called Kaggle. There's what's called Hugging Face. They provide you these vast volumes of data that you can pull from to learn from. And so people who learn how to code AI or how to approach it from a development perspective, they are used to grabbing vast quantities of it and just seeing if they can make it work, right? Because it's a very difficult process. Hyperparameter tuning alone is a big pain in the butt. Much less programming it correctly, much less coming up with something clever.
And legal teams focus on litigation and contractual risks. So again, as compliance teams prioritize regulatory adherence, they need to be in regular contact, right? They need to have a working relationship with legal and IT teams to, for example, concentrate on cybersecurity and operational resilience. Each perspective, right? Each of these different stakeholders, compliance, risk, legal, they all bring a different perspective. And while they're each valid, they all have their own priorities, they're often disconnected, which again often leads to gaps in which potentially leads to liability and exposure.
I've realized that IP isn't just a legal function anymore. It's a strategic enabler that really shapes how we are collaborating, competing, or even creating. Going back to what you mentioned, Richard, having the data sets or, for example, co-creating with other third parties, especially for corporates, with academia and other clinical partners in healthcare. So it becomes more important. How are we looking at it today?
Sometimes it can be perceived that respect to GDPR and privacy and also intellectual property can be a barrier to innovation in the healthcare. But we want to see it actually as something that triggers high quality research that value more than before. So it's a good idea to start by looking at privacy and intellectual property to see what they are going to protect.
We are living in the era of Industry 4.0, where we are talking about the artificial intelligence, machine learning, digital twin, big data analysis. And there is no doubt this technology is going to help human at immense level, and already some of the sectors are getting benefit of it. It could be education, social sector, hospitality sector, or corporate already leveraging it. But along with that, there are concerns with respect to privacy and IP remerge, and there are the going challenges in front of us. One side, IP right gives the exclusive rights to the owner, whereas the IP rights give the rights to the data principal to protect and access their personal information.